Hello and welcome to Team 5's presentation on anti-harassment laws. Before exploring anti-harassment laws and their effects on the landscape of healthcare, it is important to have a foundational knowledge of some of the policies on which these laws were built upon. What may be the most prominent of these policies was and remains the Civil Rights Act of 1964, which effectively prohibits discrimination on the bases of race, color, religion, sex, and national origin. Contained within the Act are several titles that concern voting rights, desegregation, and related topics, but where we'll concentrate on is Title VII. Title VII forbids organizations from discriminating against their employees on the grounds of sex, pregnancy, race, color, national origin, and religion, with people of these categories being referred to as protected classes. Applying not only to the federal, state, and local government levels, Title VII affects any employer and organization that has over 15 employees. Aside from establishing these principles of employment, Title VII also served to establish the Equal Employment Opportunity Commission, which serves to enforce Title VII and investigate any potential civil rights and labor violations in the workplace. Further delving into anti-harassment laws, Title VII establishes the legal definition of harassment being the unwelcome conduct against those protected classes, becoming unlawful when the offensive conduct becomes a condition of continued employment or when the conduct creates a hostile work environment. Should an employee report an instance of harassment, it will be the job of the Equal Employment Opportunity Commission to investigate all claims against an employer, and if the claims are confirmed, the EEOC will levy the proper consequences. Since harassment is a broad term, let us further break it down into some of its more common iterations. While we will touch upon sexual harassment further along in the presentation, it can include anything from unwelcome sexual advances, requests for sexual favors, physical advances of a sexual nature, or offensive comments and jokes based on sex. Offensive and discriminatory jokes and pictures can include anything from comments made from one coworker to another, to a photo of a racist nature being shared via email in the office. Assault includes the threat of physical violence against employees based on written or verbal exchanges. Finally, with ridicule and intimidation, they are often referred together under the umbrella term of workplace bullying. Now, what is important to understand about these and all other forms of harassment is that it oftentimes results in negative changes to the affected party's salary or status. Harassment can occur in a job interview. For instance, asking certain personal questions during an interview is illegal and can lead to discrimination or harassment charges. For example, asking country of origin is illegal. You can only ask if someone is a citizen and having the legal right to work in the United States. A general rule of thumb is to only ask questions of an objective nature, not a subjective one. As far as anti-harassment training goes, attendance should be mandatory and taken seriously. This could be accomplished by making it interactive by presenting employees with scenarios and asking them to explain if harassment occurred and why. Training should also show supervisors how to proactively respond to any acceptable conduct and their role in it. Sexual harassment cases can cause a great deal of consequences to any company. The number of sexual harassment complaints sent to the Equal Employment Opportunity Commission in 2015 was 6,870. Even with this statistic, 75% of sexual harassment cases still remain underreported. Some legal costs. When sexual harassment claims do go to court, the plaintiff can now pursue damages that would include emotional pain, suffering, mental anguish, loss of employment, and other non-pecuniary losses. Other reasons for poor employee turnover include that the victim feels ostracized by coworkers after bringing a case of sexual harassment to light, or even because they are unhappy with how their employer handled the claim. As far as absences go, for cases that do see a courtroom, parties involved may be absent from work periodically for court proceedings or investigations. Also, personal time may also be taken for any number of reasons connected with the emotional or physical damage caused by the alleged harassment. As far as productivity goes, employees gossip and often ask questions such as, how could this happen at our company? Why didn't they do more to prevent this? And am I safe at work? Overall, sexual harassment makes it harder for everyone in the company to get their work done in ways big and small, and that is what will likely cost the employer the most in the long run. Some more intangible effects of harassment can extend to one's own health. Harassment victims can suffer from depression, anxiety, and post traumatic stress disorder. Manifesting itself physically, symptoms can run the gamut, such as muscle aches, headaches, chronic health problems like high blood pressure, blood sugar issues, heart, and even respiratory ailments. Victims also described having a pit in their stomach while commuting to work, flying into crying fits, suffering from panic attacks, hair and weight loss, weight gain, and suffering from sleeplessness and lethargy. Harassment also extols a heavy financial burden. As aforementioned earlier in the presentation, harassment victims will also suffer a loss of career mobility and financial strain, since they tend to turn down career opportunities, drop out of research, give up tenure and opportunities, and even switch jobs or leave the industry itself. Workplace sexual harassment can result in substantial costs to companies as well. Companies often pay a heavy price for workplace harassment, in that they suffer from reputational risk resulting from a high-profile harassment case, they pay substantial legal fees and settlement claims to its victims, they lose many employees from a high employee turnover rate, and they suffer from employee absences and reduced productivity. The Me Too movement, founded in 2006, has heightened the public's awareness of sexual harassment and the determination of women to fight against domestic violence and sexual assault. The movement itself. A statement from the Me Too movement website. Our work continues to focus on helping those who need it to find entry points for individual healing. Our goal is also to reframe and expand the global conversation around sexual violence to speak to the needs of a broader spectrum of survivors. Some bill. Beginning in 2010, there were 8 states who passed laws known as the Domestic Worker Bill of Rights, which include protections from sexual harassment. The purpose of shining light onto this very sensitive topic is essentially to change how the legislative branch of the United States federal government treats sexual harassment complaints. As you can see, there are still 42 states where workers may face unclear and burdensome processes for filing charges involving harassment. As far as social media goes, the posts consisted of sharing their experiences and essentially get their story out in order to be heard. Thousands of women and some men shared their stories of sexual harassment and assault across all social media platforms. When the phrase Me Too was tweeted in October 2017, it had been used more than 200,000 times by the end of that same day. Overall, the Me Too movement is to empower individuals that are affected by sexual harassment, as well as to help reveal the extent of problems with sexual harassment and assault by showing how many people have experienced these events themselves. Just like any other occupational field, healthcare is susceptible to workplace harassment. In fact, workplace harassment is reported to be in some of the highest percentages within the healthcare landscape. The field is specifically susceptible to sexual harassment, with academic medicine having the highest number of reports of sexual harassment. It was found that about 30 to 70% of female physicians and at least 50% of female medical students were subjected to sexual harassment during their residencies by their male counterparts or superiors. Over the years, there have been an increase of sexual harassment claims within healthcare. Silent culture in healthcare is one of the primary factors that encourages workplace harassment. Silent culture is described as continual transgressions between employees not being dealt with in efforts to keep the peace at work. However, silent culture has an opposite effect than its intended goal, in which it allows incivility and harassment behaviors between employees to pervade. An example of silent culture would be an employee making inappropriate, discriminatory comments to other workers. Many fellow employees may dismiss this individual as making a joke or fail to see the severity of the remarks. However, By not tending to employee transgressions, a department therefore promotes the silent culture, allowing to transgressions like these to escalate into harassment. The healthcare system is very susceptible to sexual harassment due to its setup and demographics, factors of hierarchy, trends in gender and authority, and the aforementioned silent culture combine to create an environment in which sexual harassment can arise. Healthcare systems can be considered hierarchical, with corporate executives, top management, and physicians are considered to be top of the chain. Line employees such as nurses, imaging technologists, occupational therapists, and medical secretaries are on the lower levels of the chain of authority. Another factor that promotes workplace sexual harassment in healthcare is that the women make up the greater majority of healthcare workers. Men in healthcare typically hold positions of authority more often. In short, it can be seen that a large percentage of healthcare facilities hold more males in authority positions, with women working as their subordinates under their discretions. In addition to these factors, the silent culture creates an atmosphere in which victims of harassment are more willing to subject to various transgressions. This may be due in part that if a woman in healthcare is harassed by her male superior, she may be less likely to file a complaint in fear of losing her job or being subjected to more harassment, either from her superior or her colleagues. Here we can observe some startling facts and statistics to show the prevalence of sexual harassment in the workforce. Nearly 21% of Americans ages 18 and older had experienced some form of sexual harassment in the workplace. Moving along, you can see it affects all levels of education, with higher education eliciting a much higher response than high school graduate degrees. It affects all communities at an even rate, from those urban, suburban, and rural. Continuing along with some more statistics, sexual harassment caused an average of 52% of people to change their jobs. More shockingly, 80% of all sexual assault cases and rapes go unreported, with a similar trend being found in the workplace. This could be due to a fear of reporting sexual harassment to the employer, with an average of 32 women feeling that they can report sexual harassment and 51% of men feeling they can report it without fear. In handling this, only a minority of people feel that their cases were handled properly. Some startling facts for you. In a 20-year span, over 3,000 hospital employees at general, medical, and surgical hospitals filed claims of sexual harassment with the Equal Employment Opportunity Commission. In other sectors of healthcare, such as ambulatory care services, nursing care facilities, physician offices, and home health care services, in that same span, nearly 4,200 others filed claims as well. One-third of women in academic medical facilities reported having experienced sexual harassment in the workplace. Sexual harassment in healthcare is omnidirectional, in that it comes from both coworkers and patients. Human resources is typically responsible for composing an organization's anti-harassment policy. Human resources should go over this anti-harassment policy when accepting a new employee into the facility. They should also maintain ongoing education on healthy workplace practices and anti-harassment training to frequently remind employees of the company's anti-harassment policies. Human resources is also chiefly important in the complaint process and ruling. It is important for a company to have an anti-harassment policy to protect the organization's employees as well as the organization itself. Anti-harassment policies define harassment as a type of discrimination to be avoided in the workplace at all costs. The anti-harassment policy usually includes a specific section of sexual harassment and what constitutes it. This section may also go over inter-employee relationships and the ethics involved in such situations. The anti-harassment policy also includes instructions on how an employee can file a complaint, as well as the process accompanying filing said complaint. The anti-harassment policy also usually contains a retaliation policy that states an employee may not face any type of employment punishment, such as demotion or job loss, for filing a complaint. The anti-harassment policies should also include a confidentiality clause stating that their identity and information regarding the complaint will be kept private by the company. The first step in the complaint process is that the victim or complainant submits a complaint form to the human resources manager or director. There is usually a complaint form employees can fill out and submit to human resources, or if an employee refuses to fill out a form but still wants to make a report, the human resources director can write or dictate the report themselves. The next step is that human resources will notify senior management and review the complaint with the company's legal counsel. The director of human resources will then initiate an investigation to determine whether the complaint has a basis for believing the violation occurred. While this process is occurring, the complainant and the respondent, the person the complaint was filed about, are separated through an internal transfer, such as switching departments or work shifts, or administrative leave. Next, Human Resources, the organization's legal counsel, and management will further investigate the complaint by interviewing both parties and other employee witnesses to determine whether or not the alleged conduct specified by the complaint occurred. The summary of the findings of the investigation are submitted to the company. If it is found that a violation has occurred, the Human Resources Director recommends appropriate disciplinary action. Means of disciplinary action are determined by the severity, frequency, and pervasiveness of the conduct. Any prior complaints about either the complainant or respondent and the quality of evidence corresponding to the investigation will hold weight. Senior management will then review the investigative report, as well as statements made by complainant and respondent, and will discuss the outcomes of the investigation with the Human Resources Director. Lastly, Human Resources will meet with both parties and discuss the outcome of the investigation and, if applicable, disciplinary measures will be taken against the respondent. While the statistics and accounts we hear of harassment in the field of healthcare are startling, steps are being taken to combat this, with a concerted effort being made by the Association of American Medical Colleges. Some experts have suggested that the administration of a pre- and post-assessment during the process of harassment training to gain a better sense of employee retainment of the material. On a more active level, organizations are providing bystander training, wherein employees are taught what to do if they witness harassment firsthand. Additional measures include further refinement of reporting harassment to better protect victims from retaliation, and, if there is merit to the claims, to more severely punish those who violate the policies. To gauge the effectiveness of these avenues of education, the AAMC administers annual surveys to its member organizations. Let us now provide you with a brief introduction into the workforce harassment that the LGBT community experiences. The LGBTQ community suffers greatly from harassment and lack of career advancement in the workforce. In a 2017 study, 1 in 5 LGBTQ people reported being discriminated because of their sexual and gender identity. Gay men in particular will significantly be less likely to be in the highest paid managerial positions than comparable heterosexuals, thus being more blatant for gay men of color. This is called the gay glass ceiling. In addition, nearly 2/3 of LGBTQ employees report deriding jokes and remarks which can force them to quit good jobs. Despite all the advancements that have been made, the Civil Rights Act of 1964 and Title VII in particular still continue to be hotly contested in the courts for the LGBT community and their employers. Under the Obama administration, Attorney General Eric Holder interpreted that Title VII prohibits employment discrimination based on an individual's gender identity, including transgender status. Continuing on with this divisiveness, the most recent Attorney General, Jeff Sessions, amended the guidance and said that the act does not protect transgender workers from employment discrimination. The lower courts have been split concerning their decisions to provide protection of discrimination towards sexual orientation and transgender rights in the workplace. Currently, the United States has a conservative president and a right-leaning Supreme Court. Their decisions will have a wide effect on the LGBTQ community, even though the LGBT community receives support from many large and medium companies and the general public. And now we will give you some prior LGBTQ Supreme Court cases. Kimberly Hives was reprimanded for kissing her girlfriend goodbye in a car in the parking lot of her workplace, Ivy Tech Community College. She then suffered from harassment for several years after this incident. Eventually, Kimberly Hives was terminated from her job after teaching there for 14 years. In September 2015, Lambada Legal filed an appeal on Kimberly Hives' behalf with the United States Court of the Seventh Circuit. In July 28, 2016, the United States Seventh Circuit Court of Appeals affirmed a trial court judgment dismissing Kimberly Hives' complaint against her former employee. On April 14, 2017, the Seventh Court of Appeals reheard this case and ruled a groundbreaking 8-3 decision that Kimberly Hives suffered from workplace discrimination, which was based on her sexual orientation, thus a violation of the Civil Rights Act of 1964 and Title VII. We now give you some current LGBTQ Supreme Court cases. On June 17, 2019, the conservative slanted Supreme Court wiped away a ruling that went against Melissa and Aaron Klein, who owned the bakery Sweet Cakes by Melissa, where they refused to make a cake to celebrate the same-sex wedding of Rachel Cryer and Laurel Bauman. The Supreme Court deliberated this case for 3 months behind closed doors and resolved to send it back to the lower courts. This move is essentially buying the Supreme Court for additional time. First Liberty, the group representing the bakers, said in a statement that the court's move was a victory. Jennifer C. Pizer, senior counsel and law and policy director for Lambada Legal, who represented the same-sex couple, said the court's decision was disappointing but was confident that the lower court will rule in the couple's favor. Moving on, we have a New York case which is brought by Donald Zarda, a skydiving instructor who believed he was fired from his employer when Zarda stated that he was 100% gay when questioned about a female customer complaint. The female customer stated she felt uncomfortable about being strapped too tightly to Zarda. Zarda initially sued under Title VII of the Civil Rights Act, and his estate is pursuing this court case, being that Zarda died in a 2014 skydiving accident. The United States Court of Appeals for the Second Circuit allowed for the lawsuit to proceed, but the judges were split on how the words of Title VII of the Civil Rights Act should be interpreted, whether it should guarantee the protecting sexual orientation or only limited to sex. Finally, we come to the case of Amy Stevens, who claims she was fired from a Michigan funeral home after she started wearing women's clothing and announced she identified as a transgender woman in 2013. Stevens' boss stated that he fired Stevens because she was no longer going to represent himself as a man and wanted to dress as a woman. Amy Stevens was a competent and compassionate employee who worked at the funeral home for 6 years. Ms. Stevens stated, "I have felt imprisoned in a body that does not match my mind, and this has caused me great despair and loneliness." The Sixth Circuit Court ruled in favor of Stevens in March 2018, saying that the funeral home engaged in unlawful discrimination against her on the basis of her sex in violation of Title VII of the Civil Rights Act of 1964. The funeral home has appealed this ruling to the Supreme Court. The Supreme Court plans to hear this case this upcoming fall. Currently, the United States has a conservative government and Supreme Court, and the lower courts have been split towards their view of discrimination. There can be a major shift with the chance of public opinion in the upcoming elections. The LGBT community has taken many positive steps in the workforce since the Stonewall riots, with 21 states in the District of Columbia prohibiting discrimination based on sexual orientation and gender identity, and 85% of the Fortune 500 having gender identity included in their non-discrimination policies. The LGBTQ community needs to continue to be vigilant to push for equality on all levels in the workplace, to protect its members during the application and interview process, to provide same-sex transgender benefits, to provide LGBTQ mentorship and career assistance programs, and to eliminate harassment overall.